Hey everyone, what's going on? This is US Armed Updates, and if you're watching this right now, you need to pay very close attention to what I'm about to tell you. Just days ago, something massive happened inside a Ninth Circuit courtroom that could fundamentally change suppressor laws, not just in California, but potentially across the entire country. And I'm not being dramatic here. The oral arguments that just took place in Sanchez versus Bonta were absolutely stunning. California's attorney walked into that courtroom and basically admitted they have no constitutional defense for their suppressor ban. I'm talking about a complete meltdown on the record in front of 3 federal judges. Gun owners across America need to hear this now because what happened in that courtroom exposes the entire anti-gun playbook. And if you understand what just went down, you'll see exactly how vulnerable these bans really are. So don't click away, because the next 15 minutes are going to show you something the mainstream media will never cover. And if you're new here, welcome to US Armed Updates, your trusted source for Second Amendment law breakdowns, Supreme Court rulings, and real pro-freedom updates you won't hear anywhere else. Alright, so let's get right into this, because what I witnessed in these oral argument recordings was genuinely shocking. On November 18th, the Ninth Circuit Court of Appeals heard arguments in Sanchez versus Bonta, which is the legal challenge to California's outright ban on firearm suppressors. Now, this case has been working its way through the courts for a while, but oral arguments are where everything gets real. This is where attorneys have to stand before federal judges and defend their positions under intense questioning. And let me tell you, California's attorney was not ready for what came at him. Stay with us until the end because I'm going to play you actual clips from these arguments, and you're going to hear with your own ears just how badly the state's case fell apart. Now, before we dive into the cringeworthy moments from California's attorney, let me give you the critical background on this case so you understand exactly what's at stake here. Sanchez v. Bonta is a direct challenge to California's complete ban on suppressors. And here's what makes this even more important. Even if the federal NFA registration requirement disappeared tomorrow, even if Congress eliminated the $200 tax stamp, California would still ban suppressors entirely. You couldn't own one. You couldn't possess one. You couldn't use one, period. California treats suppressors like they're some kind of ultra-dangerous criminal tool, when in reality, they're safety devices that protect hearing and reduce noise pollution. This is pure gun control driven by ignorance and politics, not by facts or constitutional law. So what was California's main argument going into these oral arguments? Their position was actually pretty revealing about how desperate they are. The state argued that suppressors aren't even protected by the Second Amendment because, and I'm quoting their logic here, they're not weapons. According to California, the plain text of the Second Amendment doesn't even apply to suppressors, so the state can ban them without any constitutional scrutiny whatsoever. Think about how insane that argument is. They're saying that because a suppressor attaches to a firearm rather than being a complete firearm itself, it's not covered by the Second Amendment. By that logic, the government could ban holsters, sights, grips, magazines, ammunition, and basically every accessory that makes firearms functional or safe to use. You deserve to know this because this isn't just about suppressors. This is about whether states can strip away Second Amendment protections by claiming that anything other than a bare firearm isn't constitutionally protected. Now, here's where it gets really interesting, and this is the part that should make every gun owner in this country sit up and pay attention. California desperately wanted the court to avoid Step 2 of the Bruen analysis. Let me explain what that means for those who might not be deep into Second Amendment case law. After the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen, courts are required to use a 2-step test when evaluating gun laws. Step 1 asks whether the law even implicates the Second Amendment, whether it affects conduct that's protected by the plain text of the amendment. Step 2 requires the government to show a historical tradition of regulation that justifies the modern law. And that second step is where California knows they're in serious trouble. There is no historical analog for banning an entire category of arms or firearm accessories. The Founding Fathers never banned musket accessories. Colonial governments never outlawed devices that made firearms safer or quieter. California knows they can't win on history and tradition, so they're trying to convince courts that suppressors aren't even covered by the Second Amendment in the first place. It's a desperate Hail Mary legal strategy, and based on what happened in oral arguments, the judges weren't buying it. Let me play you one of the most damaging exchanges from these oral arguments. One of the judges asked California's attorney a very direct question about whether there's any real evidence that suppressors are actually used in crimes or enhance criminal activity. And listen very carefully to what the state's attorney admitted on the record. He said, and I'm paraphrasing here based on the transcript, that suppressors are rarely used in crime. Rarely. The state of California just admitted in federal court that the very devices they've banned as dangerous criminal tools are almost never used by criminals. But it gets even worse. The attorney then went on to compare suppressors to large-capacity magazines, admitting that magazines are in common use and also rarely used in criminal mass shootings, but the state still got away with banning them in Duncan versus Bonta. Do you understand what just happened there? California's attorney stood before federal judges and essentially said, yes, suppressors are rarely criminal. Yes, they're useful for lawful purposes, but we should be able to ban them anyway because we previously got away with banning magazines under the same flawed logic. I promise you, this part is critical because it reveals the entire anti-gun strategy. They're not banning things because they're dangerous. They're banning things because courts have let them get away with it before, and they're hoping they can keep pushing that envelope further and further. But here's where California's argument completely collapsed, and this is the moment that should give every Second Amendment advocate hope. After admitting that suppressors are rarely used in crime, the state's attorney pivoted to what I can only describe as a feelings-based argument. He told the court that even though suppressors aren't commonly used in crimes, when they are used, they present what he called a super-added danger that justifies California banning them based on that extraordinary danger. Think about the logical absurdity of that position. Something is rarely dangerous, rarely used by criminals, commonly owned by law-abiding citizens for lawful purposes, but the state can still ban it because in the rare hypothetical instance where it might be misused, it could theoretically be extra dangerous. Under that standard, California could ban literally anything. They could ban night sights because they make it easier to aim in the dark. They could ban recoil pads because they make it more comfortable to shoot accurately. They could ban ammunition that's more reliable because criminals might benefit from reliability. One of the judges actually pushed back on this exact point during the arguments, asking the state's attorney whether California could ban recoil pads under his logic, since they help lawful gun owners but could theoretically also help a criminal. And the attorney had no good answer. He stumbled, he hesitated, because the logic of California's position is so extreme that it justifies banning virtually anything related to firearms. And then, in what might be the most constitutionally offensive part of California's argument, their attorney actually suggested that the court should use an interest balancing test. Let me explain why that's such a big deal. In the Bruen decision, the Supreme Court explicitly rejected interest balancing. The court said that judges cannot weigh the government's interest in public safety against the individual's Second Amendment rights. The Constitution already did that balancing, and the right to keep and bear arms won. But California's attorney stood in front of the Ninth Circuit and essentially argued that the state's desire for safety, their feelings about what might make them feel more secure, outweighs any Second Amendment implications of banning suppressors. That's not just bad legal strategy. That's asking the court to directly ignore Supreme Court precedent. It's asking judges to go back to the pre-Bruen framework that the Supreme Court already told them was unconstitutional. Now let's talk about the other side of this case, because while California's attorney was stepping all over himself, the attorney representing Mr. Sanchez came into that courtroom absolutely prepared and armed with facts, precedent, and clear constitutional arguments. He opened with a devastating 1-2 punch that should have ended this case right there. First, he cited the Ninth Circuit's own precedent in a case called BNL Productions, arguing that banning suppressors meaningfully constrains the exercise of Second Amendment rights. In other words, if the government bans a tool that makes it safer, easier, or more practical to exercise a constitutional right, that ban implicates the Second Amendment. Second, he cited the Ninth Circuit's decision in Duncan versus Bonta, the magazine ban case, and pointed out that under the court's own logic in that case, suppressors are necessary to the operation of suppressed firearms, which should be viewed as an integrated whole. That's a brilliant argument because it uses California's own preferred case against them. If magazines are protected because they're integral to a firearms operation, then suppressors are protected for the exact same reason. A suppressed firearm is simply a firearm with a safety device attached, just like a firearm with a magazine inserted. But he didn't stop there, and this is where it gets really powerful. The attorney for Mr. Sanchez went further and argued that even if the court had to reach step 2 of the Bruen analysis, even if they had to look at history and tradition, there is no historical precedent for banning a particularly safe method of using firearms. And that framing is genius. He's not asking the court to recognize some new right. He's pointing out that suppressors make firearms safer for the user and those nearby by protecting hearing and reducing noise. The government has no historical tradition of banning safety devices. They've never banned ear protection. They've never banned recoil-reducing stocks. They've never banned devices that make lawful use less harmful to the user. California is trying to create a brand new category of prohibition with no historical foundation whatsoever. Now, the attorney for Mr. Sanchez did face some pushback from the judges. That's normal in oral arguments. Judges ask tough questions to both sides. But here's the difference. When California's attorney got tough questions, he had no answers. He stumbled, admitted his case was weak, and resorted to begging the court to ignore the Second Amendment. When Mr. Sanchez's attorney got tough questions, he had clear, confident, fact-based responses grounded in Supreme Court precedent and historical evidence. That's the difference between a strong case and a weak one. That's the difference between defending the Constitution and trying to work around it. So where does this leave us? What can we expect from this 3-judge panel? And what does it mean for gun owners, not just in California, but across the country? Well, I'm going to be honest with you, and I know this isn't what you want to hear, but based on the panel composition and based on 13 years of watching the Ninth Circuit operate, I don't think this is going to be the greatest outcome for us. The Ninth Circuit has a long history of ruling against Second Amendment rights, even when the law is clearly on our side. I would not be surprised if this comes down as a 2-1 decision against Sanchez, with one judge dissenting and writing a strong opinion about how the majority got it wrong. Now, I genuinely hope I'm wrong about that. I pray that these judges actually follow Bruen, actually follow the Supreme Court's clear guidance, and actually protect constitutional rights the way they're supposed to. But I've seen this movie before, and the Ninth Circuit has a terrible track record. This fight is far from over. But here's why this case still matters enormously, even if we lose at the panel level. First, a loss at the Ninth Circuit panel stage isn't the end. This case can be appealed for an en banc rehearing, where a larger panel of Ninth Circuit judges reconsiders the decision. And beyond that, this case is absolutely teed up for Supreme Court review. The legal issues are clean. The arguments are strong. The factual record shows that suppressors are commonly owned, rarely used in crime, and serve important lawful purposes. If this case makes it to the Supreme Court, it would be a perfect vehicle for the justices to clarify once and for all that the Second Amendment protects not just firearms themselves, but also the accessories and tools that make firearms safer and more effective. This is a turning point for gun owners, whether we realize it or not. And here's the hidden angle that almost nobody is talking about, but you need to understand. California's argument in this case, the argument that suppressors aren't protected because they're not technically weapons, that argument is dangerous far beyond just suppressors. If courts accept that logic, it opens the door for states to ban magazines, sights, grips, stocks, ammunition, holsters, and literally anything else they want by simply claiming that it's not a weapon itself. They didn't expect this to happen, but California has essentially laid out a roadmap for gutting the Second Amendment without technically banning guns. They can just ban every single thing you need to make a gun functional or safe, and then claim the Second Amendment doesn't apply because you're still technically allowed to own a bare, unusable firearm. That's the end game here, and that's why this case is so critically important even if you don't live in California and even if you don't personally care about suppressors. Let me also address who benefits and who gets hurt by California's suppressor ban. Who benefits? Nobody. Criminals don't follow the law, so if a criminal wants a suppressor, they're going to get one illegally, whether California bans them or not. The only people affected by this ban are law-abiding citizens who want to protect their hearing, who want to be considerate neighbors at the range, who want to reduce the noise impact of lawful shooting. California's ban doesn't make anyone safer. It just makes lawful gun owners less safe by denying them access to hearing protection. And who gets hurt? Competitive shooters, hunters, recreational shooters, anyone who values their hearing and wants to shoot responsibly without damaging their ears or disturbing others. This is a safety device being treated like a criminal tool, and it makes absolutely no sense from a policy perspective. It only makes sense if your goal is to make gun ownership as inconvenient, expensive, and burdensome as possible to discourage people from exercising their rights. Now, what could happen next? There are a few possible paths forward depending on how the Ninth Circuit rules. If the panel rules in favor of California and upholds the suppressor ban, Mr. Sanchez's legal team will almost certainly petition for en banc review and, if that fails, petition the Supreme Court for certiorari. Given the current composition of the Supreme Court and their clear interest in Second Amendment cases, there's a very real chance the justices would take this case. If the panel rules in favor of Mr. Sanchez and strikes down California's ban, you can bet that California will appeal, probably also seeking en banc review and potentially taking it to the Supreme Court themselves. Either way, this case is likely headed to higher levels of review. The legal questions are too important and too unsettled for this to end at a 3-judge panel. Don't hesitate to follow this case closely because the implications stretch far beyond California and far beyond suppressors. I also want to give you my expert interpretation based on years of covering these cases. What we saw in these oral arguments is a pattern that's becoming increasingly clear across Second Amendment litigation. Anti-gun states like California, New York, New Jersey, and others are running out of legal arguments that actually work under the Bruen framework. They're scrambling to find ways around the clear constitutional protections that the Supreme Court has established. And so they're resorting to increasingly absurd positions like claiming that firearm accessories aren't protected, that common sense safety devices can be banned as dangerous criminal tools, and that states should be allowed to weigh their own feelings about safety against constitutional rights. These arguments are desperate and they're losing in more and more courts. But the fight isn't over because these states are going to keep trying, they're going to keep pushing, they're going to keep appealing. And that's why we have to stay vigilant, stay informed, and stay engaged in these legal battles. I really read every single comment, and I know a lot of you are frustrated by how long these cases take and how often courts seem to rule against our rights. I share that frustration, but I also want you to understand that we are winning the long game here. Bruen changed everything. Heller and McDonald laid the foundation, and Bruen built the framework that is slowly but surely forcing courts to recognize that the Second Amendment means what it says. Cases like Sanchez v. Bonta are part of that larger battle. Every time California has to stand in front of judges and admit that suppressors are rarely used in crime, every time they have to admit they have no historical tradition supporting their bans, every time their attorneys stumble and fumble through oral arguments because they have no good constitutional defense, we're exposing the weakness of their position. We're building the record that will eventually lead to these bans being struck down nationwide. Thank you for being here. Your support strengthens this movement. Every view on this video, every like, every comment, every share sends a signal that Americans care about their constitutional rights and aren't going to sit quietly while states try to dismantle the Second Amendment piece by piece. You deserve to know what's happening in these courtrooms because the mainstream media certainly isn't going to tell you. They're not going to show you California's attorney admitting that suppressors are rarely criminal. They're not going to explain how absurd the state's legal arguments are. They're not going to cover the fact that pro-Second Amendment attorneys are walking into federal courts and demolishing these bans with facts and constitutional law. That's why channels like this exist. That's why your support matters so much. So here's what I need you to do. If you found this breakdown valuable, if you learned something you didn't know before, smash that like button right now. Drop a comment below and let me know what you think. Do you think the Ninth Circuit panel is going to rule in favor of Sanchez, or do you think they're going to side with California despite the weak arguments? Are you optimistic about this case eventually reaching the Supreme Court? I want to hear your thoughts, and I respond to as many comments as I can. And if you haven't already, hit that subscribe button and turn on notifications because this case is going to develop over the coming weeks and months. We're going to be covering every development, every ruling, every appeal as it happens. This is one of the most important Second Amendment cases working through the courts right now, and you're not going to want to miss a single update. The fight for our rights happens in courtrooms, in legislatures, and in the court of public opinion, and we need to be informed and engaged on all three fronts. So thank you again for watching, thank you for being part of this community, and I'll see you in the next update. Stay armed with information, stay vigilant, and never stop defending your rights.